31. This matter relates to it's a lien matter, and the respondent state of Jharkhand is not filing the counter affidavit despite last chance has been given to them right in the month of October 2023. After that, one more chance was given in December 2023, but till today, no counter affidavit has been filed. My only hope here is that before rising, this matter may be taken up so that they may be given specific direction.
They will decide it on the basis of materials on the ground. We are not going to give them invitation card for anything, isn't it? कल एक बार क्या देना?
Possible हो तो इसको
आप बोलेंगे तो 2 साल तक टाइम दे देंगे आपको क्या दिक्कत?
मेरा ये humble request था कि अगर possible हो तो आज
नहीं कल supplementary list.
For final disclosure item 1 WPL 5260/2019.
Refusal to refer the dispute to a tribunal. But the order on the challenge is that Annexure 5 of page 26.
Can you read the order?
Subject is industrial dispute over alleged illegal and arbitrary dismissal of Satilal Manji and denial of dependent employment by the management of Jharkhand to Tuliyari of National Process. My Lord, I am reading the operative portion of the refusal. Sri Shekhar Nagpal, the dependent son of late Satilal Manji, is not entitled for compassionate employment under the provisions of NCWA clause 9.4.0, as the provisions are applicable to those who expires or permanently disabled during the service period, whereas his father expired in the year 2016, who was dismissed by the company in 2010. My Lord, let Satilal
This
Manji,
order of dismissal of 2010,
yes,
has it been set aside by any competent court of law?
no,
Then there is no relationship of employer and employee ex special.
I'm coming to that.
Yes.
My Lord, this industrial dispute for compassionate appointment
That's right.
as per NCWA.
That's right.
NCWA is a settlement
That's right.
within the meaning of section 2P of the industrial
Fair
dispute.
enough.
So, my Lord, it's a tripartite settlement, settlement between management representative, workman representative, and my Lord, representative of the central government. It's a tripartite settlement. So, my Lord, in this case, the workman representative has raised this dispute for enforcement of the right accrued to an employee.
When did it accrue? When did it accrue?
2016.
2016.
He died, yes, he died in the year 2016.
He died in 2016.
And
Was he in service on that day?
No.
Matter ends. We are in 226. We cannot refer any.
But can't he,
Even if you say that they cannot decide the case on merit, but on the face of it, and this fact that he was dismissed in 2010 is not in dispute even in your writ petition. In your writ petition, you do not say that his dismissal order has been challenged before any competent authority or any court of
my
law.
Lord, that is not the subject matter of the writ
Maybe
petition.
it is not, but the point is that a person that is on the face of your writ petition and on the face of the order, there was no relationship of employer and employee between you and the management in the year 2016.
My Lord, if the matter is, my Lord, referred to the tribunal,
So?
there my Lord, the petitioner shall produce the documents that he was illegally dismissed.
No. That is not the point of reference.
Can we have a look
You
to
have the point of reference was whether you are entitled for compassionate appointment.
No, my Lord, kindly have a look to the subject of the my Lord dispute.
Yes, subject.
At the top, ID over alleged illegal and arbitrary dismissal of Satilal Manji and denial of dependent employment. So, my Lord, his dismissal was also under challenge. And that has been decided by the central government, which central government cannot. My Lord, kindly have a look to the dispute raised by the union, that is Annexure 1 at page 20.
What do you say?
My Lord, he died in the year 2000. He was dismissed from the service in the year 2010.
The
From
impute
2000
order has not been passed on the ground that it is a stale claim. That is not the ground.
The ground is that there was no employer-employee because
No.
2000.
His contention is that dismissal order plus the consequent this particular order, which essentially embarks upon the merit, cannot be sustained. Likhiye. WPL number 5260 of 2019.
Only I want to point out. In the year 2010, there was a dismissal order. Throughout his lifetime, for 6 years, he never changed.
It could be a stale claim, it could, whatever be the thing, but the impugned order has not been passed on the ground that it's a stale claim. And he is questioning not only the claim, there are two-fold contention. One is with regard to order of dismissal and the other is in connection with the dependent employment. Because if the order of dismissal goes, consequently he may have some relief on dependent employment. You can also say that it has become claim whatever, but this has to be adjudicated by the tribunal, not by the ministry. Isn't it?
Millards, whether the
You filed your counter, no?
we have filed counts. Union has also filed. We have also filed.
This is covered by telco judgment?
Yes.
Where is it?
Relying on telco jagger, servers remixtion.
Millards, there are some judgments, Millards, when it can be denied. Millards, 2008 5 है, 2007 5 है. Millards, book actually ये हो गया. अगर lunch में रखे तो I bring these judgments.
Post lunch I am not
2008
available.
5.
Post lunch I am not available.
759 para 8.
Did you hear what I said? Post lunch this bench is not available.
Millards, कल first case रख दिया जाए. I'll bring these judgments. एक बार judgments देख लिया.
तो बताइए कौन कौन सा judgments?
Millards, this is 2008 5 SCC 759 para 8.
85 SCC 759
Para 8.
para 8
2007 5
75
SCC para 8 and 12.
SCC page number please.
मिलत हम देख के बता रहे थे. दूसरा है 2002 2 S.
You give these judgments during the lunch time.
There are
Yes,
These judgments?
I'll bring these judgments during the lunch.
Madam, there are some other judgments of our own High Court, recent judgments.
You do not, you just, you have got that copy?
Yes.
Show us, give it to us.
या कल इसको फर्स्ट केस रख दिया जाए. मिलट साहब
आपके हिसाब से केस नहीं चलता है मैडम. Case will be listed in the supplementary list and it will be taken up as and when it is called up.
There is another order of this on 2024 of it. 2024, recent. Relying on those judgments.
Counsel for the parties are present. At the request of the counsel for the respondents, post this case to me. You see, if you want to file any judgment, you file it during the lunchtime. Please don't file it tomorrow.
No, today itself.
Tomorrow I will not permit anything. Whatever, because ex special, the order is illegal.
I understand.
Only at your request it is being adjourned.
I understand.
You should have come prepared with your judgments also.
Yes, Millards. Today it's Millards. No, excuse me. It's during the lunch hours I kept presenting all the judgments.
Whenever the court starts putting question, adjournment is sought for to file judgments.
Tomorrow supplements.
Tomorrow.
Item 2, Kirandujan 584 of 2021.
But this case of mine was heard by this honorable court last week.
Yes.
and by virtue of my lord's order number
I will
7
submit one
ordered
thing. As your lordships direct us to take instruction whether there is any chance of compromise or not. This OP is ready to lead conjugal life with the petitioner, but there is a huge torture, keeping in view the future of the minor girl and her future also. How long she will stay with being dependent on her parents.
No, no,
Okay.
you will be entitled to maintenance. Why do you? We do not know. You see, if you want to live, there is no problem. But we cannot put any terms and conditions. Because the law puts terms and conditions on the husband that he will not torture. And equally on the wife also, that she will also not torture.
Two times mediation was there. She returned to matrimonial house. Again, torture was there.
We
She
can't
left
do
house.
anything about it. We
She
can't do
left
anything.
house.
There
This was
are,
not
you are
the
in
issue, madam.
litigating terms.
Lord, this was not the issue, my lord.
You are in litigating terms. Now we are only concerned with the quantum of maintenance.
One thing, madam. She is ready to go. So let her go and lead conjugal life. And your lordship may monitoring this.
No,
This
no,
may
we
be
will
fixed
not
after-
monitor. We don't know.
After 2 or 3
We
months.
can't, it is simply not possible to monitor anything. It is not possible. We cannot monitor relationship between husband and wife in a
No,
proceeding like
not
this.
on that point.
We are
Whether-
only concerned with the
or
legality and
only-
validity of the order. Your whatever maintenance has been granted, that will remain intact as interim maintenance, subject to final result in terms of this Rajni's versus Neha. Simple, nothing more. That is all.
Moreover, madam, on the last occasion, you submit that the petitioner is regularly paying the maintenance amount. That is not so.
Everything will be taken care of. You have a execution proceedings also. There is no problem on that. And then
हमको तो mediation के लिए आने में हाथ में पैसा भी नहीं है. She submit in such a way. So since 2018, when the case was filed, only 1.20 lakhs has been paid, though as per calculation, more than 7 and 7.40 lakhs is there. That may be considered in passing the order. हम उनको मंगाए हैं, that is the bank account statement जो लिख कर भेजी है.
how much are you ready to pay now?
But for that, my lord, I will have to
No,
pay
you don't
this.
need to seek any instructions. They say that 7.40 lakhs are due.
Lord, I have taken
So
instruction.
you make some ad hoc payment.
Lord, regularly, my lord, there is a provision made by the employer of mine, my lord. It has been instructed to
Directly,
the bank
it
that
is
as
being
soon-
directly deducted?
Directly, my lord. Therefore, my lord, with instruction, I am saying that 10,000 rupees is directly going into the account of my wife, my lord, from the bank itself.
By which order?
Lord, some order has been passed by my employer itself. This is the instruction which has been given to me by my client, my lord. And my lord, my friend is admitting that 1,20,000 rupees has already been given to my wife, my lord. And it is being regularly paid because there is
No,
a
not
provision.
regularly paid.
You just hold on. Criminal
not-
revision, current amount you are being paid?
मतलब only हम दिखाना चाहते
Current amount are you being paid?
खाली जनवरी तक दिए हैं, उसका पहले सितंबर 23 दिए थे, जून 23 में दिए थे, अप्रैल 23 में दिए
आपका
थे.
बैंक अकाउंट है? स्टेटमेंट है, बैंक अकाउंट
हाँ,
स्टेटमेंट है?
बैंक अकाउंट हाँ, मुताबिक.
This is not a bank.
Now this is not the bank account statement, but that has been detained from the bank.
I will
account.
record his statement. Yes, he's saying on instructions that it is being debited from his account, salary account, and it's being directly credited in your account. I will record his statement.
And the ADR will be considered by the.
Everything will be considered. The law, the judgment of Honorable Supreme Court says that the maintenance will be payable from the date of filing of the maintenance
Yes, there
application.
are 7 guidelines.
All the guidelines are there and all the guidelines are to be followed. But he has also claimed that you are also working, which he could not prove.
No, madam, she is.
Therefore, that has to be placed on record by filing an affidavit.
And in
Mr.
affidavit-
Kankar, I am telling you, you will be gainful out of this order.
Yes,
Because
I
now
know that, whatever order
the
will-
salary slip which he has filed is of the month of February, right? I'm not sure whether is this the 20,000 or 21,000 is the salary which he is getting? I have my doubts about that. It is less than a minimum wages also, isn't it? Minimum
No,
wages is also higher than this.
My lord, I will be filing my salary slip.
Everything you'll have to
Lord, I
file.
will
You
be
have
also
to
filing
disclose
all
your
the
assets, liabilities,
liabilities,
everything
my
you'll
lord.
have to
That is
disclose.
what, my lord, I am looking for.
So far,
In terms of
so far income of OP2 is concerned, she has filed affidavit in the concerned court below stating therein that she has no income.
But she has not disclosed her assets and liability. Whatever, she could have some asset, maybe some jewelry, something, some assets and liability declaration is required.
Yes, ma'am.
And moreover, she will also have to file the requirement of money so far as child is concerned. The child must have started going to the school now.
Yes, my lord. She is in class 3.
Class 3,
And-
so she must be having some
And
expenses.
brother of OP2 is contributing the whatever the maintenance
Yes.
and the education charges and everything.
Yes, and the guidelines of the Honorable Supreme Court also says
Yes.
as to how the quantum for child is to be fixed. Some more
Regarding
amount,
the status
yes,
of the family.
status of the
Of the
family,
wife.
and moreover the child may
Living of-
require some tuition, some extracurricular activities. So you can just put
Yes,
it on
I
affidavit that he is undertaking this extracurricular activity. It is being paid by the brother, whatever.
Yes, my lord. Your lordship.
You are going to be
My lord,
benefited by this order
my lord,
in the long run.
my
I'll
lord,
just
sir.
give 3 months
I
time total
I
to
have
finish it off.
100% with your lordship, and I have every bharosa with your lordship.
Lick
Your
it.
lordship, you
Criminal
trust me.
Division number 584 of.
Lord, one thing, Lord, as Lord, my friend is saying that there is some possibility
No,
of
no,
Lord,
please.
compromise.
No, no, please
Lord,
no.
from my side also, my Lord, I
No,
have taken
whatever
instruction
you,
below.
if you want to compromise, you get your
Lord, one long
joint.
observation only that, my Lord, that provision of
No,
compromise
no,
may
we
be
will.
looked into by the
3
court.
months flat, this matter has to be over. In the name of compromise, it is not going to be deferred from time to time. Right? Criminal Revision number 584 of 2021. For the learned counsel for the parties. This petition has been filed challenging the order dated 27/8/2021 passed by learned Principal Judge Family Court Jamshedpur in original maintenance case number 316 of 2018, whereby the petitioner has been directed to make payment of rupees 5,000 to opposite party number 2 and rupees 5,000 to opposite party number 3 within bracket minor daughter per month towards maintenance. It has also been directed that the maintenance would be payable from the date of filing of the petition, and the arrears of maintenance was directed to be paid in 10 equal installments. Further, rupees 5,000 has been awarded as litigation cost. The learned counsel for the petitioner, while assailing the impugned order, has submitted that though the impugned order has been passed on 27th of August 2021, but the direction passed by Honorable Supreme Court in the case of Raziz versus Neha and another reported in bracket 2021 bracket close 2 SCC 344 dated 4/11/2020 has not been followed, inasmuch as the required affidavit of disclosure of assets and liabilities in terms of the enclosure to the said judgment has not been filed in the present case, and the petitioner, the present petitioner had claimed that the applicant, his wife, was a working lady. He has submitted that on this count, the impugned order calls for declaration for interference. The learned counsel submits that, as per the judgment passed by the Honorable Supreme Court, the required affidavit was to be filed in all the pending proceedings as well. The learned counsel appearing on behalf of the opposite party has submitted that only a meager amount of maintenance has been fixed. The opposite party number 2 is a school-going child. The petitioner, the opposite party number 1 has no independent source of income. The petitioner is a government servant working as a clerk in primary health care, and the impugned order does not
Health center.
primary health center
District Aurangabad, Bihar.
in district Aurangabad, Bihar. He has also submitted that there are huge arrears of maintenance
Yes.
to the tune of rupees 7.40 lakhs, and the same has not been paid, and therefore the petitioner would be the opposite party would be in great difficulty in attending the court. If the impugned order is set aside and matter is remanded for fresh consideration.
And also for the maintaining of our minor child, for her education,
That I have already stated.
personal maintenance.
At this, the counsel for the petitioner has submitted that there is already an order passed on instructions, that there is already an order passed by the employer.
Lord, it's a chief medical officer. Lord, chief medical officer, my lord, writing letter to the branch manager of SBI Dehri branch. It's a
You
Dehri.
have got a copy of that letter?
No, my lord, it's an instruction given.
Okay,
to
as per his instruction, a letter has been issued by the chief medical officer of
of that center itself.
the center
Of the center
to the banker
to the State Bank of India Dehri branch.
Dehri, THRI.
DHRI.
To the State Bank of India Dehri branch to deduct an amount of rupees 10,000 from the salary of the petitioner and credit it in the account of the opposite party number 1. And therefore there is no dispute that at least the current maintenance is being paid to the opposite party number 1. So far as the arrears is concerned, he submits that
Lord, I have
once the assets and liabilities of the respective parties are filed before the court, and upon filing of appropriate order, the opposite party shall have the opposite party will have a claim on the same.
Lord, in terms of section 128 of the CRPC.
He will not say so much.
Lord, this is what Lord Rajneesh versus Neha says in the matter
Whatever
of
it is.
execution of decree
That's
order.
In terms of section 128,
128 of CRPC, my lord, read with the relevant provisions 51,
That should be
55,
sufficient.
58,
no, in terms of the judgment passed by the Honorable Supreme Court in the case of Rajneesh versus Neha. After hearing the learned counsel for the parties and upon going through the impugned judgment dated 27th August 2021, this court finds that the relationship of husband and wife between the petitioner and the opposite party number 1 is not in dispute. It is also not in dispute that a child has been born out of the wedlock, and at present the child is living with the opposite party number 1 and is a school-going child, right? However, so far as it is further not in dispute that the petitioner is working as clerk in Primary Health Center, Aurangabad. The perusal of the impugned order suggests that there are cases pending.
There are 3 cases, my lord.
there
But
are that the parties are in litigating terms. And there are case filed by the, which includes a case filed by the opposite party number 1 under section 498 capital A and other sections of IPC against the petitioner and the family members of the petitioner. This court finds that the learned court, after scrutinizing the materials, has recorded that the opposite party number 1 has valid reason to live separately. However, so far as the quantum of maintenance is concerned, this court finds that in spite of order passed by Honorable Supreme Court in the case of Raziz versus Neha and another Supra, the required affidavit in terms of the enclosure to the state judgment has not been filed before the learned court, and it has been claimed by the petitioner that the opposite party number 1 is a working lady, though disputed by the opposite party number 1.
तो वो अपना क्रॉस में बोली है कि हम
नहीं,
उनको
cross
काम करते नहीं देखे,
That's
काम करते नहीं देखे.
That's right.
She has
Though
not seen only
disputed,
statement.
though disputed by the opposite party number 1. This court is of the considered view that the judgment passed by the Honorable Supreme Court in the case of Raziz versus Neha was required to be complied with by the learned court below, but by the concerned court, and the required affidavit having not been filed, the quantum of maintenance as fixed by the impugned order cannot be sustained in the eyes of law, and it requires a fresh consideration upon filing of the required affidavit by both the parties. However, considering the quantum of maintenance which has been fixed by the learned court and the difficulty which may be faced by the opposite party number 1 in attending the court, etc., and also meeting the expenses in connection with the education of opposite party number 2, this court is also of the view that the amount of rupees 5,000 and the amount of maintenance as fixed by the learned court is required to be paid by the petitioner to the opposite party number 1 and 2. The current amount of maintenance, till the matter is ultimately decided afresh on the point of quantum of maintenance.
Opposite party number 2 and 3. Number 1 is state.
2 and 3. 2 is the wife, 3 is the daughter. इसको accordingly change करेंगे. 2 is the wife, 3 is the daughter. Consequently, the impugned order dated 27th August 2021 is interfered with only with regard to the quantum of maintenance. The parties are directed to appear before the concerned court on, बताइए,
5th May.
5th of
May. Not 1 month.
मार्च में है ना हम लोग, तो
हाँ,
5th
मार्च।
अप्रैल ही कब होगा?
Let it be on 30th April.
8th of April, right? On 8th of April 2024, along with their respective affidavits of disclosure in terms of the judgment passed by Honorable Supreme Court in the case of Raziz versus Neha. Upon their appearance, the quantum of maintenance we appropriate order with regard to quantum of maintenance be passed by the court within a period of 3 months from 8th of April 2024. In the meantime, the petitioner would continue to pay the current maintenance as directed by the impugned order. The quantum of maintenance would be subject to the final outcome of the fresh order to be passed with regard to quantum. And as already observed by the Honorable Supreme Court, which would be subject to the by way of interim compensation, and which would be subject to the final outcome of the quantum of maintenance to be fixed.
Method, arrears.
Arrears, it will be with arrears.
Some arrears may be given.
Just a matter of 3 months. You are getting the current. It's a matter of 3 months.
That will be clarified
But you should-
with regard to the arrears, what may be input matter. Otherwise, he will flee away. He only current
अभी तो current ही देना है ना? Just a moment. The areas of maintenance would also depend upon the fresh adjudication on quantum of maintenance. This petition is accordingly disposed of. Let this order be communicated. I will just put 1 or 2 paragraphs from Rajiv versus me. I'll quote a few paragraphs from there.
But that judgment of your lordship, Lord, I have already given on last occasion. Lord,
You have given?
Everything has been quoted.
Wait, what is that judgment?
But this is a decision. I have brought it.
वो दे दीजिए.
From
इससे
para
इससे
72
थोड़ा copy paste कर देना.
72 from 92.
That's
I
right.
have correct.
We'll take it.
And para 5 of Rashid versus Iraq is also, that is also the one of the guideline. And
We are
other
just putting
guideline
all the guidelines.
is
And that judgment is always there. And you are there.
I will not be there, but on my behalf.
In your affidavit, you should clearly say that you want the arrears also.
Item 3 WPS 91 of 2023.
But in this case, we have received the counter on Thursday, the 7th of March. But with all the humidity, I was only praying for some time to file rejoinder. But the rejoinder is also ready. We'll be filing it during the course of the day. Only as a first and last chance, my Lord grants us time to file the rejoinder. We'll not be filing.
Your rejoinder is ready.
Rejoinder is ready.
Where is the counter? What is the stand in the counter?
My Lord, they have taken the aid of a judgment rendered by the Honorable Division Bench in LPA number 393 of 2017. Lord, this case is distinguishable, my lords.
Where is it? They have not annexed it. Where is that judgment?
That is there also. I have not taken
Where is it? This judgment 393?
last occasion I have given also.
They have not annexed.
I have not.
It is not there. Where do you say last occasion is this?
I have given my lord.
हमारे रिकॉर्ड से जजमेंट हम लोग इधर उधर तो नहीं करते हैं.
Because even otherwise, I am covered by my lord's judgment, my lords.
Every judgment is a judgment of the court.
My lord, that's directly on that issue.
And if there is a
Whether-
division bench judgment, and if my judgment is contrary, I will not follow my judgment.
My lord, let kindly have a perusal of this judgment. My lord, that has been held in LPA number 273 of 2020. But that has been decided on 30th of August 2023. My lord, that quietly covers my case.
That is a division bench judgment.
My lords,
Okay.
I know I will be quoting only 2 paragraphs. My lords.
No, you want to file your rejoinder, you are not ready.
My lords, I will be filing rejoinder. I'm not ready. I was just placing a reliance on the judgment passed by
this has been challenged before Supreme Court.
नहीं, that has attained finality.
Learned counsel for the parties are present. At the request of the learned counsel for the petitioner, let the rejoinder to the counter affidavit be filed by tomorrow. When do you want?
Next Monday,
Uh,
subject to Manav's convenience.
with the every day is convenient. With the consent of the learned counsel for the parties, the matter is directed to be posted on next Monday. No further adjournment will be given.
Grateful.
Don't pray for time on that. चलो, इसको ठीक से टैग कर दीजिए.
Item 4, WPS 330 of 2023.
What is this?
That is caste certificate.
Petitioner has submitted the caste certificate issued for the central government services.
Counter has been filed. Do you want to respond to that, or you are otherwise ready?
I am ready.
So this caste certificate is the same,
Central
identical,
format.
central format,
No.
but the content is identical.
No.
Please show us what is the difference in the content.
My lord, kindly see. My lord, two aspects. My lord, in
We'll come to the format later. Just tell us, just compare your format with that of the format in which central government. You just compare the central government format and your format.
My lord, I am coming on that. Second aspect is your lordship.
We'll come to the second aspect later.
For a
My
moment-
mind is stuck in that. You will otherwise also you will have to respond to that. So first respond to that. I will hear you. Don't worry about it. Do you want to file any written submissions? You have been filing in all the cases. I'm just asking you.
My lord, I will file.
Do you want to file any? Because there are numerous judgments on caste certificate.
Caste certificate.
You please file that. You have a few judgments. Are
Yes,
you aware?
Two judgments, my lord. Firstly,
You file it by Friday, both of you. आपका तो copy paste tempo पता है.
Slightly different. This is civil services, your lordship. If it is, I am allowed, subject to your lordship's presence, your lordship. If I am allowed, your lordship, time till 20th, then I am going out on Friday.
आज ही सुनते छोड़िए हमको कोई written submission का जरूरत नहीं. You argue your case.
मुझे 19 तारीख तक कर दीजिए. I will 19 पर्सनल
कौन सी तारीख को?
19 तक कर दिया जब फाइल कर देंगे. 19 तक कर दिया.
Just a minute.
Only I am praying for
19.
2 more days. 2 more days.
Okay.
moreover, my
We'll
lord,
post it on 19th.
On that day,
Take
your
it.
lordship, I will be filing your lordship. 19th, so I will be filing on 20th. It may be posted because your lordship have to go through that. Your lordship.
Okay. Learned counsel for the parties are present. The learned counsel for the petitioner has submitted that. There is no need to file a rejoinder to the counter. Counsel for the parties have jointly prayed that the matter be posted on 20th March, and they undertake to file their written synopsis, list of dates, and the judgments which they seek to rely upon latest by 19th of March. If they do not file it by 19th of March, the case will be taken up on the basis of materials on record. No further adjournment will be granted. Hold this case on 20th March under the heading of family.
Item 5, WPS 904 of 2023.
Yes, petitioner. Who is for the petitioner?
Your Ladyship, this is for compassionate appointment regarding your civic death. Death cum retiral benefits or all the benefits has been paid, Your Ladyship.
Where is the impugned order?
Your Ladyship has prepared the list of dates and
Yes, please. Counter has been filed.
Counter application has been filed, Your Lordship.
Where is the petitioner? Okay, what is the list of dates? Where is the impugned order first?
Your Lordship,
Even the minimum qualification, the
minimum
candidate is not
qualification, yes, Your
satisfied.
Lordship, that we have seen that the non-matric, because it has been considered earlier, but because of her qualification and date of birth certificate, it has been not been considered, Your Lordship.
What is his stand with respect to minimum qualification? Has he taken any stand in the in the writ petition?
Your Lordship, this is a class 4. She is. She has applied for cleaning work, Your Lordship. It's class 4.
He was dismissed also.
Your Lordship, may I have your Lordship for not today, the senior is not present for some personal medical reasons.
ऐसा तो नहीं कि इसी कोर्ट के लिए मेडिकल रीजन है, बाकी सब कोर्ट में अपीयर हो रहे हैं. We will track it. When you say medical reason, he should not be in the High Court campus. Is he there in the High Court campus?
Is not there right now, Your Lordship.
कोर्ट में झूठ नहीं चलता है, थोड़ा भी नहीं चलता.
He is not present in the court right now, Your Lordship.
I'll post it tomorrow.
Okay.
Learned counsel for the petitioner seeks adjournment and submits that on account of medical reasons, the arguing counsel is not available today. Right? If he does not come tomorrow, you are. Right? He submits that if the arguing counsel is not available tomorrow, he shall argue the matter himself. नाम बताइए अपना.
Shamai Raza.
शमाई रजा लिख के दीजिए. Advocate. List of dates आप उनको भी दे दीजिए.
List of dates. I have submitted.
To him. They are
I'll
entitled.
make one.
आप इनसे ले लेंगे क्योंकि आपको कहाँ खोजेंगे ये तो इसी कोर्ट में है अभी. ठीक है? You get it done and provide it. Post this case tomorrow. No further adjournment will be granted.
Item 6, WPS 1146 of 2023.
Lords, in this case, though I did not file rejoinder, Lords, the reason is that my client is suffering from paralytic attack, is in Bangalore. But in spite of that, Lords, now the gratuity admittedly they have not paid, the enhancement. Now they say that the state government will give a
No, you
direction.
want to argue the case?
Lords, my submission is if His Lordship give me one intelligence in the next week. Then Lords, I can, because the reason is only this. I have talked to my client, he has said, Lord, that some payments which they have made, Lord, under which category they have made the payment, one lump sum amount they have sent. Now he does not understand that on which head the payment has been.
What is the matter about? Is
Matter
it
is not
regarding retiral benefits?
Yes, Lord. He retired not as a professor from Hazaribagh University. And
Is there any serious opposition regarding his entitlement?
No.
Mr. Krishna, we can do one thing.
My lords.
We can fix one authority to take care of
My
whatever
lords.
his grievances,
Deeply aware.
and then you ensure that since he's under medical condition,
Yes.
somebody can represent him,
Lords.
and then the said person will give you all the breakup also,
My lords.
and his entitlement, and every aspect will be taken care of. He will pass a reasoned order if there is any denial, and then you will have a fresh cause of action. Because
The
pendency of this
only-
case will not serve his purpose.
Lords,
He will need more
I
money.
agree. The only thing is, Lords,
that the gratuity they admit that it has not been paid. This is the state they are waiting for it.
Admissible amount is to be paid within some time. I can just fix a time for that effect. Okay, who will take care of this? This has to be done by the secretary of the department
It
or
will
by the
be-
university.
No, it will be, according to me, government says it will be the university which will.
University will take care of that.
Your Lordship, I have filed the counter, Your Lordship, and all the retirement benefit is already been paid, Your Lordship, only gratuity, enhanced gratuity of under 7th pay commission. 10 lakh is pending, Your Lordship, which
For a person who
I
is
have
in a
written
medical
the-
condition, every penny is important.
Yes,
Right?
only asked state, Your Lordship, to give direction to pay the gratuity, enhanced gratuity. 10 lakh are already paid, Your Lordship. Only enhanced gratuity,
Remaining 10 lakhs.
remaining 10 lakh. That is
You are for
in-
the university
Yes, Your Lordship.
and who is for the state? So far as gratuity is concerned, the amount is to be released by the state.
Yes, Your Lordship.
Okay. And then upon that, it will be paid.
Yes.
Mr. Krishna, you can have two representations. One for release of enhanced gratuity amount. Have you recommended for payment of enhanced gratuity amount?
Yes, Your Lordship.
You have done the needful.
Yes, I have already written to the university.
They will close the letter.
Yes,
There
Your
is a
Lordship.
letter, no, so he will do the needful. You don't need to represent also. You can just communicate the order.
Only
your
a
counsel
specific
is there to
direction come
communicate the
from
order.
the state, then I will.
And so far as rest of the claims are
Already
concerned,
paid, Your Lordship.
already paid.
My submission is.
If there is any surviving claim, you represent before the
Yes, the difference of salary minutes for some period has not been paid.
Already paid.
We'll take care of that.
Specific.
There's only
given in
one
the
request minutes.
counter.
They should provide minutes the breakup.
Breakup, they
Yes,
will. University will provide the breakup.
That will clarify the things.
That's
That will clarify.
WPS number 1146 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the university has submitted that all the retiral benefits has been paid to the petitioner except enhanced amount of gratuity, and the same will be paid to the petitioner only upon only when it is released by the state government. He has
Or a
submitted
specific
that
direction may be given by the state to.
he has submitted that a letter dated 2/12/23 has been issued to the director technical education, director higher and technical education, Government of Jharkhand Ranchi, within bracket respondent number 3, to give the necessary guidelines, but no response has been received, and therefore the said enhanced amount of gratuity has not been paid. The learned counsel for the petitioner has submitted that the petitioner has received a lump sum amount in his account, and he is not aware about the breakup. He submits that the petitioner is suffering from paralysis and appropriate direction may be issued so that the breakup of the amount which has been paid to the petitioner is provided to the petitioner, and if there is any surviving grievance, he shall raise his grievance before the university in accordance with law. So far as the gratuity is concerned, the learned counsel submits that appropriate direction be issued to the state so that the amount is also released in accordance with law.
There's gratuity and one more minutes. We have claimed lots the leave encashment for 300 days. They have paid for 180 days.
They will take
You
care.
know, it is.
That means they will decide also.
Decided.
Everything they will decide. Whatever be your surviving grievance, they will decide.
It has, I have written, Your Lordship, in the counter, Your Lordship, that the 5018 of 2022 of the payment of leave encashment of 180 days has already been paid to the petitioner.
That's right. He
And
claims-
about 300, Your Lordship, decided in the, Your Lordship may kindly see the judgment, Your Lordship.
No, you pass a reasoned order. You refer to the judgment and pass an order. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that that admittedly certain amount has been credited to the account of the petitioner, but petitioner is not in a position to but the breakup of the same has not been provided. It further appears that the matter regarding payment of differential gratuity is now pending before the state government, within bracket respondent number 3. Considering the nature of relief prayed for in this petition, this court is of the view that no useful purpose will be served by keeping the present case pending, and as per the records, no adverse order has been placed on record regarding the entitlement of the petitioner under one or other prayer made in this writ petition. The matter is required to be looked into at the first instance by the respondent number 5, registrar, by the respondent number 5 with regard to the surviving grievance of the petitioner, and the respondent number 5,
4 and 5 requires
4 और 5 एक ही का बोलेंगे ना,
ये 4 बोलेंगे वैसा
respond, ठीक है, respond number 4. And so far as the breakup of the amount which has been credited in the account of the petitioner is concerned, the same is also required to be provided by respondent number 4 to the petitioner. The this petition is disposed of enabling the petitioner to appear before
Or his representative.
to appear before respondent number 4 either himself or through his representative by filing a representation in connection with each and every claim, and representative by filing a representation along with the records of this case. Upon such representation, the respondent number 4 shall provide the breakup of the amount which has been released in favor of the petitioner, and upon receipt of such breakup, the petitioner may file his further representation with regard to each and every claim with supporting documents.
If it is found.
Yes. If anything further is found payable, the said representation is directed to be decided within a period of 4 weeks by a reasoned order, and be communicated to the by granting an opportunity of hearing to the representative of the petitioner, and the reasoned order be communicated to the petitioner through email at the ID to be provided in the representation itself. If any amount is found payable in terms of the reasoned order, the same be also remitted to the account of the petitioner within a period of 1 month from the date of such reasoned order. So far as the gratuity is concerned, the matter is pending before the respondent number 3. The respondent number 3 is also directed to take a decision in connection with the payment of entitlement of the petitioner with respect to gratuity within a period of 4 weeks from the date of receipt of a copy of this order. The learned counsel appearing on behalf of the state is directed to communicate this order to the respondent number 3 along with a copy of the writ records. Right. If any amount is found payable to the petitioner on account of gratuity, the same be released in favor of the university within a period of 1 month thereafter, and the university is also directed to immediately to remit the same to the account of the petitioner forthwith. That's it?
Yes.
This writ petition is accordingly disposed of. This court has not gone into the entitlement of the petitioner with regard to any of the relief which has been claimed in this writ petition. अभी आपका एक राउंड और होगा because there are so many things.
एक राउंड अरे गो किलो दे भी दे सकते हैं, it is not
कुछ आपका एरियर वेरियर है सब थोड़ा सा
एरियर तो पेमेंट हो गया देख जो
Item 8, WPS 3859 of 2023.
petitioner.
The petitioner is working and working as a clerk in police department. That's right. And his charges body in nature two. By which bloody he has been assigned some work of forensic.
It is that order by which you were assigned some work.
One order they are saying they want order number 678/2022.
Yes, order number 6.
78/2022.
2022. Where is this order?
Bloody they have not given neither in the counter between they are mentioning, but that has not been annexed.
That has been mentioned in your this memo also. In your show cause also it is mentioned.
Yes.
So
Memo of charge
this was enclosed with your show cause also.
Yes. But
Why have you not
one
annexed?
Alexander Kujur
You don't shift your stand. I just want to know that it was a part of your charge sheet.
No, this is what I was saying.
Page number 31. Pradarsh,
Yes.
serial number 2.
Serial number 2.
Yes.
That has not been given only.
Not given. How do you say not given? It is a part of your charge sheet. Have you said that it was never provided to you?
But I have not written. But in the counter between also they have not.
They are not things which have already been provided to you. You have to file it. Is it your case that this letter was never issued?
No, this is not my case. My case is that not. My case is that that I, as a clerk, Mr. Lover, the inquiry, what you want held against me under Rule 828G, C, that is not applicable in my case. That is applicable only for the post of constable till inspector, and that has been given punishment under Rule 824 policeman.
I don't know.
Yes.
I don't know.
This is
No
what
such
the-
ground has been
my-
raised. You are just. Where is that ground raised in your writ petition?
Yes, read petition.
Where is it? Where is it?
Read petition.
That
also
this provision is not applicable to you.
in read petition also, as well as in installation
Show
also.
me where is it in your writ petition that this ground has been raised. That this police manual is not applicable to you. Where is it?
Yes,
Para number?
yes. Para 9 also I have punished. I have restricted. Para 9. Para 12, that will be specific. Para 12.
What is your response to para 12?
The leadership, first of all,
In my explanation also throughout before the superior police as well for the appellate authority, we have this petition has been regularly mentioned that this is not applicable.
we have mentioned in para 13 your leadership
Read
of the counter affidavit. That the petitioner was looked into, the conducting officer found the charges true against the petitioner and found guilty for not doing the duty assigned to him. And he kept the files pending in Chief Minister Public Relations Cell and it got piled up. The petitioner was given charge by DO letter number so and so of 22 of disposing the complaints of Chief Minister Public Relations Cell, but it not dispose the files. As such, he was rightly held guilty under the provision of police manual.
He says that he is not governed by police manual.
Yes,
It is governed.
it will govern, but we have subordinate service rules, but 824 rules also
Who is
says.
your disciplinary authority? Who is your disciplinary
He
authority?
works as a clerk in office of SP Saraikela Kharsawa, your ladyship.
Now, in this,
Who is your disciplinary authority?
DIG, Lord.
DIG.
DIG.
Police.
Yes, Lord.
And you are not governed by police manual.
If he is
No.
governed by
No, Rule 824 here itself says that if the ministerial work, ministerial officers will be, all the proceedings should be carried out.
दिखाई जरा police manual.
Yes.
824.
824A, Lord Civil Civil. C, 824A, Lord C. Very.
Okay. 824 capital A.
Yes, the capital A, and that is not C, ABC.
Yes.
Action against ministerial officers shall be taken according to Bihar Subordinate Service Discipline and Appeal Rules 1935. This is. And further, since the petitioner, the appointing authority by the DIG, so the DIG will be not with the by disciplinary authority. And these points we have been regularly raising with the select disciplinary police and as well as the appellate authority. But that part has never been considered.
No, I do not know. From where do you say that your appointing authority is DIG?
Yes, Lord. Chapter 27, Lord. Chapter 27 and Rule 863. Lord.
Eight 63.
863.
Yes, appointment.
Appointments. Appointments B maybe simple. Appointment of class in AD grade in district units will be made by DIG's board on the basis of results of an examination held as per Appendix 51. Appointment in rank of routine clerk etc. is made by DIG administration for those to be posted in office of DIG.
Where is your appointment letter?
Appointment is not in this period, so
We do not know. You see, who is your appointing authority? Who has issued you the appointment letter? We do not know.
by supplementary file. This is not in dispute. This only we have already on the point, and that has not been even replied in the counter affidavit.
This
Since-
863 you have not mentioned.
863.
863 you have not mentioned. That is not mentioned.
Yeah, that I can. So, parliament letter, if you also will see, will not allow me to then file a supplementary affidavit. Already, these points that I have been raising since very initiation of the inquiry.
You have mentioned about 863.
863 number, that is the rule. This is right.
This point has not even been raised in your petition.
But in
So we
counter
will not allow that.
in counter
Now your only thing is that action was to be taken in terms of your Bihar Subordinate Service Discipline and Appeal Rules. Right?
yes, that is. So we did this all the proceedings.
And regarding your ladyship, prayer number 2, the increment of salary of 5 months without cumulative effect, your ladyship, the salary has already been started, has been provided, the salaries now. The prayer number 2.
Instrument itself will be called person who is not competent.
You have not raised this plea. Please do not argue cases beyond your records. Right? Therefore, there can be many delegations we do not know. There are so many delegations in the government. If your DIG will be the disciplinary authority, who will be your appellate authority? Nobody.
Lord, this is the rule itself, Lord.
So this point you have not raised in your writ petition. You cannot argue a point which has not been raised in the writ petition. There can be many delegations we do not know.
Lord, we have some funding. Lord, in counter affidavit also, Lord, the order was managed. Now, this point has been replied by him.
This point has not been taken by you. You have not taken the point of your that the disciplinary authority did not have the jurisdiction.
Not if what was the rule 820/28G regularly since from initials of inquiry before the SP as well as before the appellate authority. These points we have been raising in my explanation itself.
Show us where have you raised?
Yes, Lord. In the explanation itself.
Show us where have you raised?
Yes.
And you have not even annexed the copy of the document.
Lord, appeal is the word. Appeal before the appellate authority. I'm showing everywhere. Before the appellate authority itself, what I have. Yes.
Where is the appellate order?
About
Where is the appellate order?
appellate order. Page 50. Page 50. And before that, what you
Annexure 8 here.
Annexure 8.
That is
Page 50, 51. 50, 51.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the disciplinary proceedings was initiated against the petitioner under Rule 828 within bracket C of
828
C होगा ना 828 within bracket C of the Jharkhand Police Manual, and the petitioner being a ministerial officer is governed by the provisions of Rule 824 capital A within bracket C, whereby it has been specifically mentioned that action against ministerial officers shall be taken according to Bihar Subordinate Services within bracket disciplinary and appeal bracket close rules 1935. The learned counsel has further submitted that the appointing authority of the petitioner is the DIG, the DIG का full form? Director?
Deputy Inspector General of Police.
Deputy Inspector General.
Inspector.
Deputy Inspector General of Police
That is responding.
/ Inspector General of Police in terms of section 863 within bracket B. And therefore, the disciplinary proceedings could not have been initiated by a subordinate officer. In the present case, the disciplinary proceedings has been initiated by the Superintendent of Police, Saraikela Kharsawa. The Learned Counsel submits that the entire proceedings are vitiated, which calls for interference. The Learned Counsel has also submitted that the point was raised before the appellate authority, but the appellate authority has also not considered the point properly. You filed a supplementary affidavit. From the records of this case, it appears that the petitioner was assigned certain work by virtue of Office Order number 678 of 2022, but the same has neither been filed by the petitioner nor by the respondents. It is further case of the petitioner that another constable, namely
Alexander
Kujur, was appointed as in charge of the public relations cell, and it was his duty to do the required work, but no supporting document in that regard has been filed by the petitioner or even by the respondents.
4/1, Alexander Kujur memo is there, lecture 4/1, page 34.
Alexander Kujur by memo number 2823 dated 3/6/2022. And therefore, there is no latches on the part of the petitioner. Learned Counsel for the respondents is directed to seek instructions and file a supplementary counter affidavit in the present case with regard to the aforesaid submissions made by the petitioner, and also annex a copy of the Office Order by number 678 of 2022 for the perusal of this court. To respond to all this, the required affidavit be filed by April 4th. Rejoinder, if any, by 24th April, post on 30th April. Oh yes, you file that supplementary. If there is a jurisdictional issue, we have no option but to interfere on point of jurisdiction. Still, you will be left with the liberty to do the needful. That letter will say, whether it is prior to appointment of Mr. Alexander or it is after, or if there is an overlapping time, that will clarify the entire situation.
Item 9 WPS 3969 of the 2023.
In this matter, last occasion it was directed to file counter whether one Sujit Kumar was appointed or not.
Sujit Kumar has not been appointed.
Yes, you
So matter is
filed
Not
the supplementary
Yes.
counter affidavit.
there is no merit in your case.
Not one chance we are given.
No, there is no question of any chance. You were measured and your candidature was rejected.
No, yes, no. Only difference between both cases, matter of Sujit Kumar was, he was height was sorted by 2 centimeters.
in Sujit Kumar case. In my case, chest of this petition was started in 4 centimeter, 6 centimeter.
We will not interfere.
No, last date it was.
We have given you more than indulgence you deserved, isn't it? WPS number 3969 of 2023, district petition has been filed for the following relief. On the last date, when the case was taken up, the petitioner, the learned counsel for the petitioner had argued that the case of the petitioner is identically placed as that of Sujit Kumar, and Sujit Kumar had moved this court in WPS number 5184 of 2021, and a direction was issued by this court to consider his case. But he was not aware as to whether Sujit Kumar has been ultimately granted the appointment or not. And this fact about Sujit Kumar was brought on record only through the rejoinder to the counter affidavit. A supplementary counter affidavit was directed to be filed by the order dated 26/2/2024. And as per the supplementary counter affidavit, Sujit Kumar has not been granted the appointment on account of the fact that upon measurement, he was not found suitable. The order in relation to Sujit Kumar has been annexed as Annexure A, which is dated 13/10/2023. The perusal of the counter affidavit filed earlier indicates that so far as the petitioner is concerned, the candidature of the petitioner was not accepted by the appointing authority for the discrepancies in the test, and accordingly his candidature was rejected and his name did not reflect in the list of selected candidates. This happened as back as on 15/4/2016, correct? Please confirm this date, 15/4/2016. This is at internal page 13 of your counter affidavit.
Notification 3346 dated 23/6/2016.
23/6, where have you stated?
Page. Decision of the.
Yes, where is the decision?
Para 12.
Para 12.
Thereafter, the state government has taken a decision to cancel the appointment under advertisement wide notification 3646 of 23/6/2016. First, counter affidavit.
खाली इतना ही लिखिए. The candidature of the petition was not accepted by the appointing authority for discrepancies in the test prior to the order passed by this court. Considering the aforesaid some statements made in the counter affidavit and the fact that the case of the petitioner and the fact that Sujit Kumar has not been ultimately granted appointment by the respondents, this court is not inclined to grant the relief as prayed for in this petition, which is accordingly dismissed.
Item 10 WPS 4593 of 2023.
If I may be allowed in addition, I'd like to place one more judgment I found in the further research
of this honorable court itself for coordinate bench. On similar issues, it has been decided. If your ladyship may come to paragraph 7, 8, 9.
Yes.
It is admitted fact that the elder brother of this petitioner died in harness on 26/2/2016. It is also admitted that this petitioner applied for compassionate appointment, but the said application was rejected. It is also admitted from the record that the elder brother, Navneet Kumar, was unmarried, died leaving behind his mother, this petitioner, and 2 married sisters. The 2 married sisters of the deceased, as they are married, cannot be said to be dependent upon the deceased. The mother was definitely dependent upon the deceased, but because of her age, she did not qualify to be appointed on compassionate ground. Thus, the petitioner has applied for grant of compassionate appointment through his mother. The claim of compassionate appointment of CCL is guided by National Coal Wages Agreement, which is an agreement between the coal company, the Union of Workmen. As per the provision of NCW, a dependent is entitled to get compassionate appointment. A dependent, as per NCW, means the wife, husband, as the case may be. They are quoted 9.3.3. In this case, the petitioner is an indirect dependent as per NCWA, being the brother of the deceased. As per NCWA, if no direct dependent is available for grant of compassionate appointment, the case of indirect dependent is considered. In the instant case, the mother being the direct dependent was not eligible to be appointed on compassionate ground, as there was no other direct dependent. The petitioner applied for the grant of compassionate appointment through his mother, but his claim was rejected, treating him not a dependent of the deceased because of the reason that the address of the petitioner in voter ID card and Aadhaar card is different with the address of the deceased, and he got his education from some different place. Now, if your ladyship will come to paragraph number 11 on the next page.
Just can you read it?
So far as dependency of the petitioner is concerned, there are several documents of the respondent authorities as mentioned above which clearly prove and suggest that the petitioner was a dependent upon the deceased. The petitioner has pleaded and came up with documents of the respondents to prove that the petitioner was a dependent of the deceased. When the petitioner asserts his dependency, then the onus will shift upon the respondent authorities to prove that he was not a dependent on the deceased, which the respondent authorities have failed to do. Nowhere the respondent CCL has ever pleaded or submitted that the petitioner is working and is independent in earning. Moreover, the report of the foreman committee of the CCL also suggests that the petitioner was a dependent of the deceased. This report is a conclusive proof on the fact of dependency of the petitioner upon the deceased. In view of the aforesaid facts, the impugned order dated such and such, passed by senior manager such and such, by which the claim for compassionate appointment of the petitioner has been rejected, is absolutely bad and the same cannot be sustained. The petitioner, being the dependent of the deceased, is entitled to be appointed by CCL on compassionate grounds. Accordingly, the order impugned is set aside. So my case is fully covered under this judgmental edition.
What was the ground for rejection?
The ground for rejection was
in this case.
In my case.
In this case.
In this case. That the petitioner is not a dependent of the deceased.
That is a separate thing.
Ma'am, in my case also, they are.
What happened to this? Any appeal filed against
No,
this?
kind of see this judgment. An old judgment of 2006, but a very popular case passed by Honorable Minister. This is Kari kindly see para 30. Para 30.
Yes.
From bare perusal reading of clause 9.3.2, it is manifestly clear that if an employee dies in harness, the dependent shall be provided employment or monetary compensation. Clause 9.3.3 makes it clear that the word dependent means wife or husband, as the case may be unmarried daughter, son, and legally adopted son. They are termed as direct dependents, and any one of them shall be provided employment. Only in case where no such direct dependent is available for employment, then in that case the brother, widow, daughter-in-law, son-in-law residing with the deceased and wholly dependent on the earnings of the deceased may be considered to be the dependents of the deceased. I have therefore no hesitation in holding that in the event of death of a worker, only the wife or husband, as the case may be, unmarried daughter, son and legally adopted son shall be entitled for employment. For example, if a worker dies leaving behind the widow or unmarried daughter or son or adopted son, they cannot claim employment in favor of brother, widowed daughter-in-law or son-in-law inasmuch as they are not direct dependents of the deceased employee. Here was the case when the son-in-law wanted employment. But the court said no. Once the widow is there, she would be entitled to monetary compensation, and the son-in-law cannot get.
You offered monetary compensation.
Yes.
The widow, no, in this particular
Yes,
case which you are citing, you offered monetary compensation, or she was otherwise eligible for appointment?
No, she was not eligible. She was above 40.
She was, where do you say this?
Therefore, the court says, last paragraph, consequently, the petitioner widow shall be get monetary compensation from the respondent. Last but one line. Respondent's case is that the petitioner widow, however, can pursue her claim for monetary compensation as per eligibility under the provisions of NCWA Para 3.
In the other judgment, in WPS 7312, there was a
Widow was there.
And there was a clear order by this court to grant him compassion.
Yes. I cannot
You have complied that? Must have complied, isn't it?
That instruction.
Must have complied.
If no appeal has been filed,
We do not know whether appeal has been filed or not filed. So you cannot have it that way, no? You cannot have contrary stand. In one case you do not file appeal, and in another case you oppose.
No, this was of CCL, which he is citing is of CCL.
Same principle.
I am saying
Same principle, same NCWA.
Same.
Then
There is no dispute on that.
we'll refer it to division bench. There are contrary view. You explain it before the division bench as to why don't you bring on record the judgments which are passed by other coordinate benches.
I was
This
not
is
aware.
what whosoever is there, BCCL, CCL, they are one and the same. So far as NCWA and entitlement under NCWA is concerned.
Our only contention is that the widow is available, and they are guided by 9.5.0.
But their contention is widow is here asking for employment of indirect dependent.
This case is also can be distinguished on the point that here the daughter was also available. In his case, apart from widow, daughter-in-law, there is no one in the family.
Yes.
So his case stands on a different footing.
From
and much
which
better,
case?
His case, and a much better footing than this Kari Devi, which I am citing. Because no one is available apart from the widow, daughter-in-law.
And in this Kari Devi, the daughter was also available. So he will be entitled as per WPS 7312, right?
Yes. Only the dependency part may be ascertained by BCCA.
That's right.
That was already done, ma'am. Your ladyship, if your ladyship may come to annexure 8, this was submitted.
Otherwise, your entitlement will be verified. Otherwise, there could be many things, no?
Yes.
Which they need to verify. Where is the impugned order?
Your ladyship, annexure 10, at page number
34.
34.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner, while assailing the impugned order, has submitted that the claim for compassionate appointment to the petitioner number 1, who is the widowed daughter-in-law of petitioner number 2 and dependent on the ex-employee, namely,
Kati Mehto.
namely
Leadership KATI.
KATI Mehto, who died in harness on
14/6/2020.
14/6/2020, has been denied only on the ground that the petitioner number 2 would be entitled for monetary compensation and as per NCWA, her demand to provide compassionate employment to the indirect dependent, that is petitioner number 1 of the ex-employee, cannot be considered. The learned counsel has submitted that the national coal wage, that the provision of national coal wage agreement has been wrongly applied to deny the claim of compassionate appointment to petitioner number 1, although the petitioner number 2 is agreeable for grant of compassionate appointment to petitioner number 1 and she is not interested in taking monetary compensation in lieu of compassionate appointment. The learned counsel has relied upon a judgment passed by this court in WPS number 4312 of 2017, passed in the case of Jitendra Kumar Pandey versus Central Coalfields Limited, dated 28/2/2019, to submit that in the said case, the widow of the deceased employee was there and the brother of the deceased employee was seeking compassionate appointment.
Mother of the deceased employee in this case.
A widowed mother of the deceased employee was there but the brother of the deceased employee was seeking employment. The learned counsel has submitted that the present case is wholly covered by the judgment passed in WPS number 7312 of 2017. The learned counsel, appearing on behalf of the respondents, on the other hand, while opposing the prayer, has referred to a judgment passed by this court on 10th May 2016 reported in 2006 within bracket 3 bracket close JCR within bracket JHR Kari Devi versus Bharat Coking Coal Limited and has referred to paragraph 13 thereof to submit that it has been held that if a worker dies leaving behind the widow or unmarried daughter or son or adopted son, they cannot claim employment in favor of brother, widowed daughter, widowed daughter-in-law or son-in-law, inasmuch as they are not direct dependent of the deceased employee. However, in the said case, the daughter of the deceased employee was alive and there was a claim for compassionate appointment in favor of son-in-law. And admittedly, the daughter could be the daughter falls under direct dependent.
वहाँ भी गड़बड़ हो जाएगा because she is married the son-in-law उसी से उसका शादी होता है married daughter is not entitled. She also gets outstayed.
और जो इन्होंने जो जजमेंट साइट किया है उसमें widowed mother is there. Widowed mother is not a direct dependent as per NCW.
Right.
Right? So, claim of widowed mother falls under indirect dependent at best.
She would not get either monetary compensation nor employment.
Nor employment.
Yes.
आप समझ रहे हैं? आपको बात समझ आ रही है? ना तो employment मिलेगा ना monetary compensation मिलेगा. You are not entitled to both. Then under such circumstances, the claim for compassionate appointment of widowed daughter-in-law will revive.
Here in this case, she would be the widowed wife. Why?
In this particular case,
Yes,
which we are deciding,
yes.
in this case, this petitioner number 2 is the widowed mother of the ex-employee.
No, she is the widow. She is the widow of the ex-employee.
She is the widow of the ex-employee.
Okay, she is the widow of the
Yes,
ex-employee.
that's why we are saying that once the wife is there, widowed wife is there, the other persons cannot claim.
We will decide it. That requires a proper decision.
Yes.
I have recording your submissions.
Yes.
I will post it for a judgment. I'll give it a thought. आपने तो नहीं किया research, कुछ हम करेंगे.
Yes, I also talked to them. They also said the same thing, that there are hundreds of cases of this type where the son-in-law or the widowed daughter, indirect dependent, gets employment. They flow away from the house. The direct dependents, we are assuming case. What would happen to the widow? Suppose she gets remarried and goes away with her husband. The widow would be the sufferer.
We will pass a judgment on
Yes.
this.
And in case the
counsel for the respondent has also referred to the provisions of clause 9.33 to submit that there are two classes of dependents. One is dependent and other is indirect dependent. The dependents are the persons coming as dependent, coming under the category dependent are wife/husband, as the case may be, unmarried daughter, son and legally adopted son. And in absence of any direct dependent, there are other categories, namely brother, widowed daughter-in-law or son-in-law residing with the deceased and almost wholly dependent on the earning of the deceased. The Learned Counsel has referred to clause 9.5.0, which deals with employment/monetary compensation to female dependent, and has submitted that in case the female dependent is 45 years of age, she will be entitled only to monetary compensation and not employment. The Learned Counsel submits that in the facts of the case, when the widow is available, but widow of the ex-employee is available but is above 45 years of age, she would be entitled for monetary compensation, and the claim of any indirect dependent cannot flow out of the provisions of National Code Wage Agreement.
One more thing, monetary compensation is being paid in lieu of employment.
He submits that the monetary compensation is being paid in lieu of employment. He has also submitted that merely because the widow is not claiming monetary compensation, the same will not entitle the indirect dependent to claim employment. यही है आपका केस? इसमें जजमेंट के लिए डेट दीजिए. कोई और जजमेंट मिले तो आप प्लेस कर दीजिएगा. खोज तो हम लेंगे ही. That is for sure. दूसरे हाईकोर्ट का मिले तो भी. I think there is some confusion in your organization regarding this. Is there any?
Yes, sir. Interpretations are still on. Yeah.
We'll take care.
There is one development. Earlier, we did not keep the name of female dependent in live roster. The lordship, because male dependents were kept in live roster. Now, in this NCWA, we have done away with it. Female dependent would also be kept on the live roster.
Pose this case for judgment on date. 30th April. 30th April.
Item 11, WPS 5925 of 2023.
Petitioner.
Your Lordship, I am also praying for
No, this. That's right, but this case has become infructuous practical. Because you just see, call him please. You just call him by 1 o'clock. Where is the petitioner? If he is absent, we'll pass the order. This case has got nothing. Nothing has survived. Nothing survives in this case.
Item 12, WPS 6941 of 2023.
Your Lordship, I pray for pass on for few cases because Mr. Anil Kumar ASI has to argue in this case, Your Lordship, and he is
become infructuous now.
No, Your Lordship.
No, we finally rejoined the Lordship permits us.
Saying what?
No, we just controverted 2-3 things in the contract.
You see, the grievance with regard to this son having his
That
exam
alternate-
is over.
That alternate, that those was in an alternate. Your Lordship will see that is in the alternate.
No,
Those-
this is
that-
what
that
I'll say.
alternate-
You see, that period is over.
That is a part of the alternate prem, that is not part of the main prem.
You were not appearing on that day.
No, I was not.
So that is why you don't know what happened. We adjourned the matter only to ensure that the exam is over.
That the exam is over.
Exam is now over.
But the point is now he's gone to class 11 and 12. He needs to be more than any time more else. That is the point. But there are 2-3 things which I wanted to indicate through this matter.
You had only 2 grievances.
Right?
Right?
Yes.
In your representation, you had only 2 grievances. You were claiming childcare leave.
Yes.
Yes.
That still
For the
survives. That's still.
They have said in their counter affidavit that once you join, it will be considered. We'll pass an order that your claim for childcare leave will be considered even now.
That is
For this period, we will ask them to
But
consider.
that is the only prayer I'm making, Lords. It would be really unfair on their partners to ask me to go and join and then consider.
No, they
Because
will,
what-
you will, as it is, you will have to go and join because your crisis is now over.
This crisis has begun.
No.
11-12 is also.
No, that is a separate application.
Correct. If your lordship kindly allows me to place
You
the
can
counter.
you can go there and apply for fresh childcare leave. But
I
this
will.
period during which you have remained absent can be adjusted against childcare leave. As
But this
simple
is
as
not
that.
as I was protected by an interim order of this.
Therefore,
Therefore,
the
this-
interim order was protecting you because there was an exam.
Correct. Your lordship, my only kindly allow to place this page 19 of the counter affidavit.
Your lordship
He
pass off
praised
this is your
a
lordship
Passover.
because
I understand, Merz. I understand the limitations I have in the matter. The only rare Merz I have before your lordship today is in view of their statement because the ITBP has not filed the counter affidavit.
You forget it.
The
We will
CRPF
protect
has.
you accordingly because there was an interim order.
Correct.
By virtue of interim order, you continued in the same position. Now that period for your for the exam of your child is over, we can also direct them to consider this period
Then that
for
will-
your child care leave.
that Merz they will. But my only point is they are in the affidavit saying that since may I just read Merz, since she is under order of transfer to ITBP, DIG Medical CH Ranchi, that is CRB, may consider a case for sanction of CCL after obtaining
That's
concurrence
right, that will be done.
So
We
I'm
will
saying
take care of that.
there are two things.
You see, this particular period, either it will be treated as absence without leave or it will be treated as child care leave, nothing else.
But this period of
Nothing else.
because I was under
Because
the
now this, you were not there, Mr. Bharat Kumar was there
yes,
on
he's
the
still
last
there,
day.
but he's still there.
Yes, he's still there. It was clearly adjourned with a clear understanding that by the next date, the case will become infructuous so far as the exam of the child is over.
Yes,
An
that is over.
appropriate order will be passed so that this period can be
Today
treated
I'm-
as child care.
I'm only making a different request. Merz.
No,
That is
we will not, there is no question of any different request.
In view of the affidavit, what has been stated in the affidavit, two things can be kindly considered.
You
from this
have to
point.
join, Mr. Sinha, you can't avoid joining.
No, I don't want.
Otherwise, in absence of any sanctioned leave under child care, you are under scrutiny in the departmental proceedings.
That Merz, I understand.
Yes.
My concern is kindly here. Just if your lordship gives me a minute. My only thing is that they can also consider without me insisting on my joint. Number one. Number two, there is an ITBP hospital in Ranchi also.
Your prayer is rejected.
But
Your prayer will be rejected. If you make that prayer, I will reject it.
the Ranchi one,
I will reject it. I can reject it.
The only thing is they can sympathy sending me to lay or
Sympathy,
Arunachal
you see, a
Pradesh.
working lady, there is no question of any sympathy. You have any right, you will get it.
I have a right
Rights
only
you
to
do not
CCL.
have, you have to be treated at par with anybody
No,
else.
that's true, Merz. That's the only right is flowing from the child care.
That's right.
The child care, I'm just trying to say, Merz, to send me somewhere and then consider it and then send me back. That
No, this particular period,
Yes, Merz.
the period is over.
Period
The
is-
child care period is over.
No,
If you
I
want,
still have 9 months.
No, you have 9 months.
Yes.
Then you go and apply for fresh 9 months. That will be a fresh application. So far as this intervening period is concerned, for the conduct of examination of your child, class 10, that is over.
That is all.
You can apply afresh.
Yes, Merz. I can apply.
You have to apply afresh.
And they are
Because
saying, they are saying we can
no,
do that.
no. They say that even for this period you were supposed to join and apply.
No, for this period, they are only saying, if I have understood what they are saying is right, is
You
they're saying
you
for-
read and understand. You were not there on the
I have
last.
understood, Merz.
We are just passing it over. He will be here by 1 o'clock. We will pass an
Right.
order. I am making my mind very,
No,
very
I have
clear.
understood your lordship's mind, but I am trying to convince your lordship on a point that instead of sending me back and then coming back, not only.
No.
Your
That will not
lordship
happen.
in rejoinder.
You will have to join, file a further application that you need further time for childcare because he is now going to study in 11 and 12.
12. Because every child is different. That's the only reason.
That's right.
So they have ground, but to send me back, therefore I was only making no done.
No.
I have understood your lordship.
You call Mr. Anil Kumar,
Yes.
1 o'clock. Second half I am not available. You better be
Yes,
here.
yes.
Otherwise you seek instructions and argue the case.
So your lordship normally take the rejoinder on record first?
Yes, yes, it on record.
Item 13. WPS 7336 of 2023.
When have you been relieved? And where are you working right now?
On the transfer post.
I do
During
not
the
know. Where are you discharging your duties right now?
I'm discharging my duty right now at Saraikela Kharsuma. I have annexed the document also
Your
whereby
transfer order is from?
from माइनस with 88 page 41 क्षेत्र शिक्षा पदाधिकारी जमशेदपुर पूर्वी सिंहभूम का ऑफिस से जिला शिक्षा पदाधिकारी सरायकेला खरसमा.
From JSR to Saraikela.
Yes.
Where are you working right now?
At Saraikela Kharsama during the pendency of this requisition, I was compelled to join, so I have joined.
When did you join?
Keeping my rights reserved on 9/2/2024.
But you were relieved on
I was
20/12/23.
Yes.
When were you relieved? Sorry, date please. Twenty-one
21/12/2023, for which I filed the IA challenging that relieving also.
You filed the writ petition on our very next day,
Yes.
22nd, after being relieved.
Yes.
Yes.
Because the basis of transfer is that there was a rationalization policy that it should be ensured that in one office there is no persons working more than the strength, sanctioned strength. So a policy was adhered to that in a district a person should not remain for more than 6 years, and in a particular office a person should not continue for more than 3 years. For this purpose, a detailed exercise was undertaken by the exponents, which is reflected in
Where is that policy?
Annexure 4, 10/11/2023. And for this purpose,
Kindly refer to the policy.
yes. Page 15, Annexure 4. Resolution. स्कूली शिक्षा एवं साक्षरता विभाग झारखंड रांची अंतर्गत
You
क्षेत्रीय
come to the relevant portion only. You don't need to read the
relevant portion I want to show from page 23, where the complete figure is there, which I want to highlight.
Not on the figure. The policy. I want the
The policy is
We are
one
not
page
concerned
only. I
with
will
the
be allowed to read it. Page 15.
No, it is 3 pages policy. You just read the relevant portion.
Manus?
You just read the relevant portion. 6 years and 3 years. Where is that?
That Manus should get. At page 12, Annexure 2. संथाल परगना प्रमंडल दुमका में लिपिकों के स्थानांतरण पदस्थापन करने के उपरांत पुनः पुराना पदस्थापन स्तर पर उनका नियम विरुद्ध प्रतिनियोजन करने के मामले में विभाग के संज्ञान में आए हैं। ऐसे मामले प्रायः सभी प्रमंडलों में होने की सूचना प्राप्त हुई है। इन कार्य में क्षेत्रीय शिक्षा उपनिदेशकों की भी सहभागिता परिलक्षित हो रही है। मामले गंभीर अनियमितता एवं प्रशासनिक विफलता का परिचायक है। उसके आलोक में निम्नवत आदेश दिया जाता है। नंबर 1, सभी क्षेत्रीय शिक्षा उपनिदेशक झारखंड यह सुनिश्चित करें कि कोई भी लिपिक एक कार्यालय में 3 वर्ष से अधिक पदस्थापित न रहे। ऐसे लिपिक जो अन्य जगहों पर व्यक्तिगत कारणों से सेवा करने में असमर्थ हैं, उनके अनिवार्य सेवानिवृत्ति प्रदान करने पर विचार किया जाए। मंत्रिमंडल सचिवालय एवं संबंधित विभाग के झारखंड रांची द्वारा निर्गत अधिसूचना संख्या इतना दिनांक इतना के अनुसार स्थानांतरण पदस्थापन की कार्रवाई वर्ष में एक बार मात्र मई जून में ही की जानी चाहिए। अतः उक्त स्थानांतरण पदस्थापन की कार्रवाई जून 2020 में की जाए। इसकी तैयारी शीघ्र कर ली जाए। जिला शिक्षा पदाधिकारी सरकारी विद्यालयों में लिपिकों को पदस्थापन भी उसके अनुसार ही करे। एक विद्यालय में 3 वर्ष से अधिक अवधि तक कोई भी लिपिक पदस्थापित नहीं रहेगा। इसका अनुसरण विशेष सचिव सह निदेशक माध्यमिक शिक्षा रांची की अध्यक्षता में की जाएगी। उप प्रस्ताव को विभागीय प्रधान सचिव का अनुमोदन प्राप्त है। Now this was there, and another is notes in one page. If is annexure 1 notes that I have notes annexed, and then this annexure 3 comes. And annexure 4 gives the details how a person or how many persons are at one place. And then in course of this rationalization, it is found that in which office how many persons are working.
Annexure 3 is your transfer order.
No, I am referring to annexure 4.
What is annexure 3?
Annexure 3 is by this I was posted at this place. Notes, I was in suspension was revoked. Then I was posted in this office from where I am being sought to be transferred.
Can you read annexure 3?
जिला शिक्षा माइनस will find in the विशाल प्रताप सिंह लंबित शिक्षा कार्यालय इतना आरोप पर गठित करते हुए कार्रवाई संचालित की गई थी। जिस जिला शिक्षा पदाधिकारी संचालन पदाधिकारी सरायकेला चंद्रमान के क्रमशः पत्रांक इतना द्वारा उपलब्ध कराए गए जांच प्रतिवेदन में श्री सिंह पर लगाए आरोप प्रमाणित नहीं पाया गया है। जिला शिक्षा पदाधिकारी सह संचालन पदाधिकारी सरायकेला चंद्रमान से प्राप्त जांच प्रतिवेदन के आधार पर श्री विशाल प्रताप सिंह निलंबित अफसर को निलंबन से मुक्त कर संचालित विभाग की कार्रवाई को विस्तारित किया जाता है। निलंबन मुक्ति के पश्चात श्री सिंह को क्षेत्र शिक्षा पदाधिकारी जमशेदपुर के कार्यालय में लिपिक के रिक्त पद पर स्थानांतरित किया जाता है। सो इन दिस ऑफिस आई वाज पोस्टेड on 25/10/2023. Name is Area Education Officer, Jamshedpur. Notes, in this office I was posted only on 25/10/2023.
By virtue of revocation of suspension order.
Yes.
You remain suspended from 8/7/23.
Yes, yes. This document has been annexed only with a view that I was posted in this office on 25/10/2023 only, and just after 1 month and 5 days I am being transferred from this place.
Where is your transfer order?
Just for this purpose.
Where is your
My
transfer
order is my lord at page 40, annexure 7. My name appears at serial number 16, page 41.
Serial number?
16
Page number
was
40.
Page number 40, but my name appears at 41, serial number 16, Vishal Pratap Singh. I am being transferred from Kshetra Area Education Officer, Jamshedpur.
It's a chain transfer.
Madam?
It's a chain transfer.
Yes, many persons, 18 persons were transferred.
आपका सारा पेज निकला हुआ है, ऐसे पड़ा हुआ है, क्या करें? टैगिंग है प्रॉपर नहीं कुछ.
Chain transfer.
Page number?
41, 41. उस सब के बाद हो. उस सब के बाद.
के निकल गया बाहर.
उसके बाद. Yes.
Yes.
Annexure 7, page 40. मैं just place this. विभागीय पत्रांक 330/50 जो हम अभी शुरू में दिखाए. दिनांक 10/11/2023 के आलोक में दिनांक 11/12/2023 को संपन्न प्रमंडलीय शिक्षा स्थापना समिति की बैठक में लिए गए सर्वसम्मत निर्णय अनुसार निम्नांकित लिपिकों को उनके नाम के सामने अंकित कार्यालय में निम्नांकित शर्तों के साथ सामंजित स्थानांतरित कर पदस्थापित किया जाता है. हमारा नाम है पेज 16 पर. योर लेटरशिप विल फाइंड एट पेज 41 आइटम 16 विशाल प्रताप सिंह, क्षेत्रीय शिक्षा पदाधिकारी जमशेदपुर से जिला शिक्षा पदाधिकारी सरायकेला खरसावां. Date is important, 11/12/2023.
So this a number of persons have been transferred.
हाँ, that's
You are not the
chain
solitary
transfer.
one.
Chain transfer हम repeat कर रहे हैं, chain transfer है. तो chain transfer हुआ तो उसका रीजन है कि क्यों ट्रांसफर हुआ, कि एक ऑफिस में ज्यादा लोग पोस्टेड न रहे, वही 30-50 लेटर है. My posting is here on 25/10/2023, annexure 3, page 14. I have shown to your ladyship 25/10. And I am being sought to be transferred on 11/12/2023. 1 साल 5 महीना I have counted, and they have also come to this conclusion. Now before I proceed further, just your lordship will be pleased to see page 35. It starts from page 34 itself, forwarding is page 34. The basis of transfer, rationalization कि एक ऑफिस में ज़्यादा आदमी नहीं रहे ट्रांसफर. My office is at page 39, last page, serial number 81. क्षेत्र शिक्षा पदाधिकारी जमशेदपुर पूर्वी सिंहभूम. मेरा नाम है, दूसरा कॉलम में विशाल प्रताप सिंह. पेज नंबर 39 I'm referring. I'm very sorry that it is not properly tried. Page 39, serial number 81. मेरा ऑफिस है क्षेत्र शिक्षा पदाधिकारी जमशेदपुर. नाम है मेरा विशाल. उसके बाद लिपिक है, डेट ऑफ अपॉइंटमेंट. एक्सट्रीम राइट साइड माय लॉर्ड्स विल फाइंड कि कौन सा 6 साल और 3 महीना वाला जो सवाल होता है, तो उसमें हमारा नाम के आगे लिखा हुआ है वर्ष में 0 है, माह में 1 महीना है और दिन में 5 दिन है. और 6 वर्ष वाले में भी है कि 1 महीना है और 5 दिन है. मतलब इस ऑफिस में और इस डिस्ट्रिक्ट में राइट नाउ जो हमारा पोस्टिंग लास्ट हुआ उसके बाद से मात्र 1 महीना 5 दिन हम यहाँ से रहे. So this is the first fact which I want to bring to my lord's notice, that it is a transfer within a period of 1 month and 5 days. Second is page 23. Just facts I am giving, then I will make my point. They have done this. Page 23, my office is item number 37. स्वीकृत बल है टोटल हमारे ऑफिस में 2. पेज 23, सीरियल नंबर 37, ऊपर से दूसरा, क्षेत्र शिक्षा पदाधिकारी. तो स्वीकृत बल है यहाँ टोटल 2 और कार्यरत बल है 2. I am one of them. I have made some such pleading that there is no excess clerk posted over there, so there is no question of transferring me on the basis of this rationalization, on which other persons have also been transferred, of course, because excess persons were there, so they were transferred. Now these are the facts. Now the question of law which I want to just place is, and for that purpose I want to show one document, which is their document, it is not mine. Supplementary counter affidavit that they have filed by respondent number 3 on 19/2/2024, 19th of February. Supplementary counter affidavit. First is the counter, then supplementary counter. I want to show that this is a punitive transfer. (9 to 2024), annexure is B at page 10. He is writing to the director, the joint education director, regional joint director of education is writing to the director, and he says about me at page 11 bottom, next page, the reason of transfer. उपरोक्त वर्णित विवरणी के अवलोकनोपरांत यह पाएंगे कि श्री सिंह की नियुक्ति से अद्यतन एन के प्रकारेण लगभग 7 वर्ष 16 दिन तक पूर्वी सिंहभूम जिले में ही पदस्थापित एवं कार्यरत रहे हैं. I pause here for a minute. My ground is that I am being transferred in a time span of 1 month and 5 days. He says that no, he has remained in this district for 7 years and 16 days. मतलब पूरा जो कैरियर में हम जब यहाँ ट्रांसफर हुए ना, सबको काउंट करके कह दिए कि हम 7 साल यहाँ रहे हैं.
कब से कब तक कहाँ रहे हैं?
हाँ.
आप दिए?
कब से कब तक हम
हाँ,
यहाँ?
कब से आपका अपॉइंटमेंट हुआ है?
पूरा एंटायर सर्विस कैरियर में.
नहीं, we do not know. You see, he says that you have been here for 7 years, 16.
It is true. I say it is true.
But not in continuity.
This
where do you say that it was not in continuity?
I have said so after I gave a reply to this.
Where is that reply?
इसी से रिफ्लेक्टेड भी है ना, इसी से
नहीं,
रिफ्लेक्टेड.
आप हमको बताइए.
इसी लेटर से भी रिफ्लेक्टेड है कि ये कंटिन्यूएशन में नहीं है, क्योंकि पूरा सर्विस करियर हम रहे हैं यहाँ 7 साल. ये फैक्ट है. आई एम नॉट डिनाइंग दिस, बट नॉट इन कंटिन्यूएशन. दिस माय लॉर्ड्स में टेक. देन ही सेज फर्दर, जहाँ तक हम पढ़े कार्यरत रहे, उसके बाद वाला 3 लाइन इज वेरी इंपॉर्टेंट. श्री सिंह के विरुद्ध जिले के कई निजी विद्यालयों के प्रबंधकों के द्वारा अधोहस्ताक्षरी को मौखिक रूप से यह शिकायत प्राप्त हुई है कि निजी विद्यालयों में बच्चों के नामांकन कराने के एवज में अनावश्यक रूप से दबाव व हस्तक्षेप करते हैं. So a complaint was received against me and therefore this transfer. What is the complaint? That I am making unnecessarily pressure upon the private schools to take admission. This was the complaint on the basis of which I have been transferred. Now the point for my consideration is that on the basis of complaint, if a transfer is given effect to, then this transfer is bad, and I rely upon a judgment for this purpose. 2015 volume 3 JLJR page 444. 15 का 3 JLJR.
That's right.
This is one.
Para number?
7 to 16. This is one. Second is.
One is sufficient. Why do you need to multiply?
सिर्फ एक दे देते हैं. 2013 का 4 JLJR page 703. There are many judgments on this point, but I am citing only two. 13 का 4 JLJR page 703. 13 का 4 JLJR page 703. And the third judgment, which is very relevant for the purpose, that if a person joins on the transfer post during the pendency of the writ petition under coercion, then there will not be any impediment for this court to interfere. And the citation for this purpose is 2008 Division Bench Judgment, 2008 Volume 2 JCR, page 306. Uttam Kujur versus State of Jharkhand. 8 का 2 JCR, page 306.
That's all.
Relevant paragraph is paragraph number 14. And
where is your joining under protest?
That I have said in my joining, which is enclosed with my rejoinder. At page 12 of my rejoinder.
That is all?
12.
For a transfer matter, this much of argument is sufficient.
तो एक लाइन का बहस है कि it is a punitive transfer. They have admitted that it is a punitive on the basis of complaint you have been transferred.
That's
so
right, yes.
two judgments
What do you
are
have to
there.
say?
No, my lords, it has not been admitted by us. My lords may see the supplementary affidavit filed by us, my lords, dated 6/3/24, my lords. RI 9, page 4.
Six 3/24. There is no such affidavit. Dated 6/3/24. One is 30.
7/3.
15/2/24 I have. 23/2. 7/3/24. Yes.
Lords may see para 5. It stated that on 10/11/23, Department of School Education and Literacy Jharkhand comes with a resolution number 3046 in which decision was taken that for rationalization of class 3 and class 4 employees, the employees shall be transferred as per the rules. And on 16/11/23, an answering respondent published provisional seniority list through memo number such and such where name of the petitioner appears in the said list. that on 11/12/23 a meeting of the Regional Education Establishment Committee was held and where a decision has been taken for transfer of class 3 and class 4 employees. That as per the meeting of the said committee on 11/12/23 the petitioner has been transferred along with the other employees. That on the basis of transfer of 21/12/23 the petitioner has been relieved from the Range Education Office, Jamshedpur and issued memo number 104. That due to not joining in the order period on 30/12/23, an explanation has been asked to the petitioner by the answering respondent. Now that's the para 11. That no any complaint was received by the answering respondent against the petitioner. The petitioner was transferred as per the departmental resolution number 3046 dated 10/11/23.
That's right.
For rationalization.
WPS number 7336 of 2023. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner was under suspension by virtue of letter dated 8/7/2023, and ultimately when the petitioner was not found guilty, ultimately a decision was taken to revoke the order of suspension, and by order contained in memo number 814 dated 25/10/2023, he was placed in the office of regional, he was placed as क्षेत्र शिक्षा पदाधिकारी क्या हुआ?
एरिया
अच्छा, एरिया एजुकेशन ऑफिसर जमशेदपुर ईस्ट सिंहभूम in the vacant post of clerk. The learned counsel submits that within a period of 1 month 5 days, the petitioner was again transferred by virtue of transfer order contained in memo number 993 dated 11/12/2023 as contained in Annexure 7, which is under challenge. The learned counsel submits that the transfer of the petitioner within a short period is not sustainable, as such frequent transfer is as such transfer is contrary to their own decision, as contained in Annexure 1, 2 and 4 of the petition. The learned counsel has referred to the counter affidavit and has submitted that the transfer order is a punitive one, inasmuch as in letter number 20 dated 4/1/2024, it has been observed that there has been complaints from the private schools that complaints from the private school in the district of East Singhbum that he has been pressurizing the private schools in the matter of admission and in the matter of their administration of the school. The learned counsel has relied upon judgment passed by this court reported in 2013 /4 JLDR 703 HC Suman Kumar Sanam versus State of Jharkhand, decided on 22nd October 2013, and also judgment reported in 2015 SCC Online JHAR 1676 Damodar Prasad Mehto versus the State of Jharkhand and other analogous cases, decided on 1st April 2015, to submit that if that transfer on the basis of complaint is a punitive transfer. the learned counsel submits that during the pendency of this writ petition, he has joined the transferred post under protest, and therefore mere joining will not be an impediment in setting aside the order of transfer. The learned counsel, appearing on behalf of the respondents, has opposed the prayer and has submitted that and has referred to the supplementary counter affidavit dated 7/3 supplementary counter affidavit filed on 7/3/2014, and has submitted that on 10/11/2023 the Department of School Education and Literacy, Jharkhand, came with resolution number 3046, in which decision was taken for rationalization of class 3 and class 4 employees, and that the employees would be transferred as per rules, and the provisional seniority list was published on 16/11/23, and has submitted that as a sequel to the policy and the decision was taken to transfer the petitioner via resolution number 3046 dated 10/11/2023, and no complaint was received by the authority, and therefore the transfer is not a punitive transfer. That is all.
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the petitioner was under suspension and was under suspension, and by virtue of memo number 814 dated 25/10/2013, the petitioner was posted at in the office of Area Education Officer, Jamshedpur East Singhbhum, and within a period of 1 month 5 days, he was transferred by virtue of impugned order of transfer dated 11/12/2023 as contained in Annexure 7. Upon perusal of Annexure 7, it appears that a number of persons have been transferred, and it is not an isolated case of transfer of the petitioner. This court also finds that the justification regarding transfer of the petitioner has been given in the supplementary counter affidavit dated 7/3/2024, which is from, and the stand taken is from paragraph number 5 to 11, which is quoted as under. So far as this court is of the considered view that so far as the interference in the matter of transfer is concerned, the scope is very limited, and interference is generally called for only when the transfer is otherwise tainted with malice or is a punitive transfer. From the perusal of Annexure B, as contained in letter number 20, dated 4/1/2024, this court finds that it has been mentioned therein that there has been a number of complaints against the petitioner while he was posted in district of Singhbhum East, and he had remained there for a total period of 7 years, 16 months.
16 days.
7 years, 16 days. And during his period, there were oral complaints regarding his interference in the admission of the students in the private schools. However, the letter contained in letter number 20 dated 4/1/2024 does not reflect that the same was a reason for his transfer. The said letter is subsequent to the order of transfer of the petitioner. Upon perusal of Annexure 7, it is clear that there was chain transfer and it was not a case of isolated transfer. In the aforesaid circumstances, this court is of the considered view that the transfer of the petitioner cannot be said to be punitive, and considering the totality of the facts and circumstances of this case, the improved order of transfer does not call for any interference. Accordingly, this petition is dismissed.
Orders item 14, WPL 2777 of 2017.
As per the last order, we filed the requisites, but on the file, the same has been returned as undelivered.
Undelivered. Karamchari Panchayat, you take personal steps. How will it remain undelivered?
I'll take personal steps.
The learned counsel for the petitioner is present. As per office note, undelivered registered cover has not been received. As per the office note, the notice was issued on 19/6/2017, but undelivered registered cover has not been received. Upon this, counsel for the petitioner undertakes to take personal service of notice upon the sole respondent. The requisites for personal service be filed before this in the registry by this Friday.
Since it's a company matter, 1 week time will be granted. We will
Company
file-
will give you instructions to file requisites for service of notice. Then you raise your bills whenever you want to. Right? Company will pay all your bills. The affidavit regarding service of notice be filed before this court by 2nd of April 24. Post this case on 3rd of April. One more thing. From the perusal of the records of this case, it appears that the petitioner is relying upon order dated 23/11/1982, stating that it was decided that joining of the workman would be considered on the condition that his age would be recorded as 38 years, certified by the medical doctor. However, the said document does not appear to have been exhibited before the learned court. It further appears that, as per the case of the respondent, the respondent was made to superannuate on 1/9/2004, and his actual date of superannuation was 30/9/2009, and by the impugned order, the entire back wages has been granted for the period from 1/9/2004 to 30/9/2009, although as per the case of the respondent, the workman had expired on 29/4/2005. Therefore, the differential could be only till his death.
Yes.
Only this much of relief can be granted. That document is not exhibited.
We'll bring it on record.
You can't bring it on record. things which you have not exhibited before the court, you can't bring it on record. बस रहेगा आपका third post on third. You have been asked to file your supplementary affidavit regarding service of notice by 2nd of April. Post on third, under the heading for final disposal.
Passport case item 11, the LPS 5925 of 2023.
Yes, petitioner. This case has become infructuous. You just have a look at the IA. Para number 5. No, para number 7. Para 5, 6 and 7, sorry. You have issued
average remarks.
That for the year 2022 from average to very good. They say.
So far as 23 is concerned, that is still there.
Sorry.
But so far as that period in para 7 they are saying, humbly submitted that the respondent authority soon after upgrading 22 ACR of the petitioner issued ACR for the year 23 of the period 1/1/23 to 15/5/23 by giving average remark only to harass the
So
petitioner.
how does that make a difference? What? It cannot be a case of harassment at all.
No, that so far as that part is concerned, therefore, so far as this part, the application which has been made. This is in fact an amendment petition. Where you not see from paragraph 11. Paragraph 11 is with regard to
It is listed for orders? No.
This is admission.
Nobody appears on behalf of the petitioner on account of repeated calls. The ASGI is present. This petition is dismissed for non-prosecution. They may not be interested also. Are you closed?
Passport case
There
item.
put condition.
Passport case item 12, the LPS 6941 of 2023.
We wish to withdraw its implicit amendments.
Withdraw?
There is no contest.
WPS number 6941 of 2023. Counsel for the parties are present. Learned counsel for the petitioner seeks permission to withdraw this writ petition. Any objection? No. The learned counsel for the respondents has no.
This is to join to the transfer
For
case.
this writ petition is dismissed as withdrawn. Interim order vacated.
Fine. Item 15, the LPS 6257 of 2023.
They have entered appearance for respondent number 4 and 5. 6 weeks time to file the counter. 4 and 5 is respondent college.
Instead of 65, St. Paul College retired me at the age of 60 years. And long time avoiding, the university is also.
4 and 5. Who is for 4 and 5?
Yes.
You are?
I have entered the filed the wakalat number last Friday.
You want to file counter?
We filed 6 weeks time to file the counter.
6 weeks?
Only
Why?
one request.
All the college they get 65 years age and
Maybe admitted there is some differences. This is not a minority college, first of all, and more so they are not aided also.
Okay.
So therefore, some information
they-
I need from the college itself. The principal and secretary is just procuring those documents.
They are not aided also. Then this writ petition
So
would
therefore,
lie.
I'll raise that issue.
It may go to Jharkhand Education Tribunal.
That may be a plea, but then I have to seek in.
The learned counsel for the parties are present. The learned counsel appearing on behalf of private respondent number 4 and 5
The respondent colleges.
submits that he has entered appearance recently. The learned counsel has also and prays for 6 weeks time to file a counter affidavit in this case. The learned counsel has submitted that the St. Paul's College, that the respondent college, to the best of his information, is not an aided college, and therefore this court may not entertain this writ petition, as the petitioner would have appropriate remedy before the Jharkhand Education Tribunal. Let the counter affidavit be filed by respondent number 4 and 5 by 30th April.
University may also file the counter.
Sorry?
University
State has not
also-
filed counter affidavit.
University department.
State has not filed counter affidavit.
No.
You file your counter? The counter affidavit on behalf of the respondent state, we also filed much before the next date. Post this case on 2nd of May. 1st of May.
For press filing item 16, WPL 816 of 2019.
How is this writ petition maintainable?
Your Lordship, this order has been passed by the Deputy Commissioner, Your Lordship. And he's also chaired as Workmen Compensation Commissioner, Your Lordship.
You had moved in a miscellaneous appeal against the same order.
Yes, Your Lordship.
Then?
And thereafter that was dismissed for default, Your Lordship.
Yes, then?
For non-prosecution. And when CMP was filed for
Yes.
restoration of the same, Your Lordship.
Yes, then?
And that was dismissed for the barred by limitation, Your Lordship.
That's right.
And further thereafter, this WPL we have filed for the reason that the order was passed by the Deputy Commissioner, Workmen Compensation Commissioner, Your Lordship.
So do you want to say that the MA was not maintainable?
Since it
No
was-
liberty has been reserved with you by refusing to restore the MA.
I was just saying, Your Lordship, a week time.
No adjournment will be done.
For the reason, Your
WPL
Lordship,
number 816 of 2019. This writ petition has been filed for the following relief. From the perusal of the records of this case, it appears that one MA number 345 of 2005 was filed challenging the impugned order, and the said MA stood dismissed for non-prosecution.
This is for default.
Dismissed for default and thereafter CMP number 321 of 2015 was filed for its restoration with a petition for condonation of delay of 2705 days, and the said CMP number 321 of 2015 was also dismissed by order dated 6th of August 2018. Thereafter, the present writ petition has been filed challenging the same order. Considering the aforesaid facts and circumstances, this writ petition is dismissed as not maintainable.
Okay.
Next.
Item 17, WPS 296 of 2023.
Lord, they have taken up this. We concede for the petitioner out of this.
Should matter related to transfer of the petitioner's function.
Counsel for the petitioner seeks adjournment. Come back.
Next. Go with it.
You have filed memo number 8 dated 2/3/22 pursuant to the last order.
No.
Why have you not filed it?
It will be fine.
In a transfer matter? Has he joined the transferred post? Or you are helping him not to join?
No, Lordship, as per the transfer rule, the transfer which had been made to the petitioner was in contravention with the transfer rule. Then thereafter, the transfer which has been made, it has been cancelled also. So what is the current status? I will seek instruction and I will file supplementary.
The counsel for the petitioner seeks adjournment on 26/2/2024. The counsel for the state is also seeking adjournment. Pose this case on 18th of March 2024, it is made clear that there is no interim order granted in favor of the petitioner so far. Next.
Item 18, WPS 419 of 2023.
Yes, petitioner.
See, this is a case of retired employee who had not granted the 5th pay scale and revised 6th pay scale. And even the salary which he had received also, that has been also recovered from the pension.
Counterfiled?
The state has done that counter. The state has said the university has to give the papers. University has not supplied.
University is a party.
Yes, both university has been parties.
Learned counsel for the parties are present. A counter affidavit has been filed by the state, but no counter affidavit has been filed by the university so far. Let the counter affidavit of the university
4 and 6.
be filed by 3rd of April, rejoined by 30th of April, post on 6th May. Next.
Item 19, WPS 4980 of 2023.
In this matter, there was a direction to file a counter affidavit and to pay the admissible dues. Admissible allowances we have already paid lots, and only 2 days time may be granted for filing counter affidavit lots. We have gotten instruction to file.
Admissible dues has been paid.
Whatever admissible has been paid, and number of departmental proceedings is pending against him.
That's what is admissible? He has already attained the age of superannuation. Right? He has not been dismissed so far. So you must be giving him the retiral benefits. Have you paid him the retiral benefits?
As per instruction, lots of admissible dues has been paid.
What is admissible dues? 1 rupee, 2 rupee? What is admissible dues?
Lots of only 2 days we will file the contract.
Well, have you received any money?
My lordship, substances are announced, I could not get my lordship. And
Have you
there is
received your post-retiral benefits?
only GPF and GIS they have given.
Pension?
No, my lordship, there is another, it is pending and the honorable this court has given direction to file the counter affidavit, they did not file the counter affidavit.
Wait,
also.
what is the other case?
Another,
And what is the date?
on 1st April this has been fixed.
That is relating to post-retiral benefits.
Yes, my lordship.
WPS,
And
you have the case
one
number?
another, my request is that to clear this, the order has given by this honorable court and they are not ready to comply the order.
WPS, please hold on.
Yes,
WPS number 4980 of 2023. Counsel, the petitioner is present in person. Counsel for the state is present. The counsel for the state has submitted that admissible dues has been paid to the petitioner, but prays for time to comply with the order dated 21st of February 2024. Prays for 2 days time, right? Pose this case on 1st of April. साथ ही में सुनेंगे दोनों.
My humble submission is, please, club one another.
No, it can't be like
2910. That is your honorable. This honorable court has given order, and the contempt is pending, my lordship.
No, nothing.
Item 20, WPS 5795 of 2023.
Petitioner.
Your Ladyship, this is the case where ad hoc appointees are being replaced by another ad hoc arrangement. The petitioners are working as part-time teachers in Kasturba Gandhi Balika Avasiya Vidyalaya in Basant. There are total 10 petitioners, Your Ladyship, and they have all been appointed between 2018 to 2022. Now, Your Ladyship, on 20th 9th 2023, that is under the signature of the District Education Officer Godda, an advertisement has been floated inviting applications for contractual teachers in the same school where the petitioners are working as contractual teachers.
You are all trained teachers.
Yes, Your Ladyship. The qualifications.
Are you all trained?
The qualifications have been stated in.
You file your contract with it. Counsel for the parties are present. Let a contract with it be filed in this case by 1st April. Rejoinder by 4, post on 8th.
Only one request, Your Ladyship. The advertisement may kindly be stated as the
We are
coordinate
not going to
benches.
stay the advertisement under any
The coordinate benches, Your Ladyship, of the same court has in the same identical matters have stayed.
If one court has stayed the advertisement, it stands stayed for everybody, isn't it?
Yes, Your Ladyship.
So no fresh order required to be passed.
Thanks, Your Ladyship.
For admission, item 21, WPL 2144 of 2015.
Against the same award, Your Lordship, another writ petition has also been filed.
Who has filed it?
It has been filed by the Union, Your Lordship, that is numbered as WPC number 4272 of 2021, Your Lordship. Let both the matter be heard together. I pray for time in this case for construction of the fact. Ladies and gentlemen, kindly sit.
One more writ has been
One
filed.
year, that is by the workman against the same award. So that award is challenged by the management as well as the workman. So it would be better if both cases are listed.
WPL number 2144 of 2015. Counsel for the, you are for the workmen?
Yes.
Counsel for the parties are present. They have jointly submitted that arising out of the same award, another writ petition being WPC number 4272 of 2021 has been filed. अब C लिख दिए हैं उसमें इसीलिए ना यहाँ नहीं आ रहा है.
They have filed.
आप गलत लिख दिए ना उसमें.
The WPL
WPL कर दीजिए.
4272.
They submit that both the matters are required to be heard together. Let this matter be tagged with WPL number 4272 of 2021. यहाँ सारा ही है ना WPL हम लोग के पास. And be posted on क्या regularization?
Absorption.
Absorption.
एक खाली records भी मंगाना पड़ेगा इसलिए हम बोल रहे थे.
And we posted on 20th of March. 28th March, but 24th March 2024. Let the records be called for from the concerned court. 24th March. 24th, sorry, 24th नहीं, 24th April. Sorry.
Records.
Records I have already asked for.
Records of reference number 323.
वो अपने से मंगा.
Item 22, WPL 5587 of 2017.
एक बार रिकॉर्ड्स आ जाने के बाद काउंटर वाउंटर का कहानी नहीं होगा, फिर रिकॉर्ड से बहस होगा. प्लीज अगला डेट में टाइम मत लीजिएगा ये बोलने के लिए कि काउंटर. आप लोग को जो रिटन सबमिशन फाइल करना है अपना तैयार कर लीजिए और हम अगला डेट में सुनेंगे इसको. काउंटर फाइल करना है, जो करना है आप कर लीजिए. बिकॉज वंस द रिकॉर्ड्स आर देयर द मैटर एंड्स.
There's nothing required.
Nothing is required.
Only the records would speak for itself.
Yes. Petitioner.
इसमें उधर इम्प्यून ऑर्डर जो है वो मिसप्लेस है, इसलिए हमको एक्स्ट्रा अकोमोडेशन दिया जाएगा. महाराजा अपना फाइल है उसी से. कहीं फोटो वगैरह कराने में तो लगता है।
Impugned order.
Yes. ये पेज 49 से 53 तक।
Counsel for the petitioner seeks adjournment. You are for the private party.
No, no, second question.
Where is the private party? Notice has been served.
Yes.
In spite of service of notice, the respondent number 2 has not entered appearance. Post on 30th April.
Item 23, WPL 2461 of 2018.
For time, one order is to be annexed and will come to court.
What order?
The petitioner has
The award
preferred
is
earlier
here.
also in 2006. And that's what the case was dismissed.
What are you seeking?
And I have not gone through the.
What is the date of death?
Date of death is your leadership.
23rd, 6th, 96.
And you are seeking compassionate appointment?
Yes, Your Lordship. And first time the application was made on 23/3/2004. That is 8 years after the death.
And what is the order of, where is the order of rejection?
Also, my reference is denied.
Or reference has been denied.
On the ground of delay. Also.
That's right. Fair enough. Fair enough. And your writ petition was also dismissed. Where is the question of reference?
Writ petition was dismissed on 2006.
2016. 2006.
Six.
In 2006.
देखिए. WPL number 2461 of 2018. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that by the impugned order, the reference has been by the impugned order, the reference has been denied. Counsel for the respondents has submitted that the reference has been denied on account of delay. The date of death of the ex-employee is 23/6/1996. Right? And the application for compassionate appointment was filed on 23/3/2004. And earlier one writ petition being WPS number 1249 of 2006 filed by the petitioner for compassionate appointment was dismissed, which is apparent from the impugned order itself.
Impugned order dated 12/1/2018.
12/1/2018. Considering the aforesaid facts and circumstances, this court is of the considered view that the impugned order by which the concerned authority has refused to refer the dispute for adjudication has been rightly passed. The impugned order does not call for any indifference.
Item 24, WPL 1858 of 2019.
We say petitioner has sought quashing of the notice as well as the letter contained in annexure 3 series, whereby my lord, without giving any opportunity of being heard to the petitioner, in contrary to the provisions of section 20, subsection 3 of the Minimum Wages Act, the petitioner has been directed to pay the digital amount for sum of rupees about 66,000 that is being awarded in terms of section 20, subsection 5 of the Minimum Wages Act.
It says that ample opportunity was given to you.
Well, that is only, but that is what they are that no
it is record, it may be called for. I have not.
It is for you to annex a copy of the records.
It was not duly served to the petitioner. He
From
has
where
not
do you say
received
that?
any notice from
Where
the.
do you say that you did not receive any
I have
notice?
stated in my petition.
Where is it?
You petition I'm paying for some short pass over Mr. Ravi Prakash Hajra is to appear in this case.
Paragraph you have stated. That paragraph T.
Read it, please.
That it is a matter of record that the notice was not validly served upon the petitioner by the office of the General Lieutenant 11 Commissioner Central Patna, and as such the petitioner remained ignorant about the alleged payment to be deposited by him in violation of the provisions of subsection 23 of the Minimum Act. And directly followed this notice was request letter was sent to the
WPL number 1858 of 2019. The learned counsel for the petition has submitted that there has been gross violation of principles of natural justice in as much as no notice was served upon the petitioner before passing the improved order. The counsel for the respondents is directed to seek instructions and file a counter affidavit. In this case, let the records of minimum wages claim within bracket 66 bracket close 14 between Dilip Bhagat represented by Shri Dilip Bhagat Lessi Bhagat Para Pakur decided on 10/8/2015 be produced before this court. 2015 का ही order हुआ था ना? You say that no opportunity of hearing was granted. You will produce it? You produce the records of the minimum wages. They say that it is ex parte. पता चल जाएगा service हुआ कि नहीं हुआ?
I will produce.
And file your counter also. It seems that the certificate proceeding is going on. You just find it out whether he has represented before the certificate court also or not. Pose this case on 30th April 2024. The counter affidavit be filed by 4th April, by 10th April, rejoinder if any by 16th.
Not the one prayer, not the copy of the petition, because
They did provided.
today itself not so that I become.
Kindly provided. Second half I am not there. There is one matter fixed at 2:15, but it will not be taken up today. एक मैटर है 2:15 के लिए. उसको थर्सडे को करते. थर्सडे को है. थर्सडे को देखिए तो कोई 2:15 बजे रखें क्या वैसे. उसी दिन करेंगे. थर्सडे को 2:15 बजे.